you need to start thinking about what you're doing. And if you don't want to do the right thing for yourself, then do it for your children.
Facing a serious drug charge, 32-year-old David Barfield III walks into court hoping to avoid prison. But the judge quickly challenges his mindset.
All right, the court is calling 2025 CR 0115118 State versus David Barfield III. Could I have parties announced for the record?
Orlando Weiss for Mr. Bearfield.
And are you Mr. Barfield? All right, Mr. Barfield, the court previously informed you and informed your attorney that I have previously represented your uncle, Christopher.
Yes, ma'am.
Did you have a chance to discuss that with your attorney?
Yes, ma'am.
And are you waiving any conflict I may have? What I can tell you is I'm going to be fair. I don't have any conflict. All right. Okay. Defense, have you had a chance to speak with your client?
We did, Your Honor, and he had no conflict with you presiding over his case.
All right. Counsel, have you received all discovery in this case, and did you review it with your client?
Yes, Your Honor.
The court will find that the state is in compliance with discovery. Cindy, do you need a cough drop or water? I do. Okay. It's one of those days. You know how they say, I know it like the back of my hand? Well, I got a little bit lost because I looked at my hand. I'm like, I don't recognize that. See what happens when you age? All right, Mr. Bearfield, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Bearfield, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? By indictment, you're charged with possession of a controlled substance penalty group 1, 4 to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You understand? You're going to need to speak up so that the court will. Do you need a break, Cindy? Let me know when you're ready or if you need a break. Okay. All right. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, counsel, and the right to remain silent? Counsel.
Yes, Your Honor.
Yes,
Did you
ma'am.
understand? Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Bearfield, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine and the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation. 120 hours of community service restitution, the DOEP course, MRT, and anger management. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead?
No, guilty, no contest.
No,
No
you have a
contest.
choice, guilty,
No contest.
not guilty, or no contest.
I'm not used to
That's okay. So how do you plead?
no contest.
State, any evidence?
No objections, Your Honor, for purposes of the plea.
And state, is there a reason the request for anger management?
It will be in the stip, so
Okay,
that piece was, or I guess, to stipulate the evidence that stipulated to was turned into our office. I'm not sure why this was not generated, but when I went back to the discovery, I thought that this was very part of.
all right, thank you. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor,
Anything you wish to say on behalf of your client?
that the court follow the plea agreement that we have arranged with the state of Texas.
All right, how old are you?
32.
32. Do you have any children?
Yes, ma'am.
What are their ages?
8 and 13.
And do they live with you?
No, ma'am.
Do you have regular contact with them?
Yes, ma'am.
Are you employed?
Yes, ma'am.
What do you do?
I'm a quality inspector.
And what are you expecting?
Beverages.
I'm sorry, what?
Beverages.
Okay.
Yes, ma'am. For 5 years.
I'm sorry, what?
Been doing it for 5 years.
If you're drug tested today, what would the results be?
I'll give it negative.
Okay, why are you doing this?
I would just say I was at the wrong place at the wrong time.
No, you were not at the wrong place at the wrong time because that pink, according to the stipulations, the pink backpack was yours.
According to stipulations.
I mean, do you want to be in prison?
No, ma'am.
And let me just tell you, the reason why I ask these questions is because you need to start thinking about what you're doing. And if you don't want to do the right thing for yourself, then do it for your children. Because I'm telling you, if you go to prison, by the time you are released, your children will not recognize your face, won't know who you are. They'll be calling someone else dad. You need to step up to the plate and start doing your job and doing better. And making the Bearfield name a good name because you're the third. And if the second and the first before you didn't do the right thing, then you need to do something. You understand? All right, this is what the court is going to order. There's a $1,500 fine that will be probated. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 40 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Do you live by yourself?
No, ma'am.
Who do you live with?
My grandmother.
Okay. Why? Why don't you have your own place?
It's because I've always lived there. I take care of my grandma.
How do you take care of her?
I just make sure I'm there to give her love and care.
Do you pay bills at that location?
Yes, ma'am.
Don't be a freeloader, all right?
No,
Make sure you pay the bills there and don't bring drama and chaos to your grandmother's house. What I've learned from my time as a prosecutor and defense attorney, usually people are at grandmother's house because grandmother is just, sleeping, not on top of everything that's going on in their house, and people just use her house as a hangout. Do not do that to your grandmother. You understand?
Yes, ma'am.
And they're going to be field visits at that house. So there's to be field visits one time per month until further notice. The MRT course, 120 hours of community service restitution. Did you graduate from school?
No, ma'am.
Why not?
Something happened at school and I just didn't get back to complete.
All right. I'm going to order parenting classes. Once he completes parenting classes, 60 of those hours will be deemed satisfied. For the remaining hours, you can either do 60 hours, which they're going to have you outside picking up trash in the heat. They're probably not going to let you do anything while it's cold. It'll be during the heat, right? You can either do those 60 hours or either you can obtain your GED or some type of trade school certification. 5 years deferred adjudication. And anger management. Probation, is there anything else? Is there anything else you need from the court in order to be successful? I'm sorry?
Let's see. Gonna go over the misdemeanor time.
I'm sorry, what? Okay.
No.
We do want to clarify something for the court, Your Honor. You said no unsupervised visit with minors. Does that include his children?
Mhm. Until, once you completed the parenting classes, then I usually lift that. And let me just tell you why in this court, normally I will give people parenting classes. The reason why I do that is because when people are picking up offenses, they're not thinking about their children. And you need to realize that your children can't take care of themselves and they're 100% dependent upon you and your support. And if you're in jail or if you're in prison, you're not able to support them. So those classes, I've actually taken a parenting class because I like to see what I'm asking people to do. Depending on which person is giving the class, those classes are very informative for you. And it's something that you can probably add to whatever you've already learned from your parents, the good things, okay?
Yes.
All right. So is there anything else you need from the court to help you be successful on this probation?
No, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. And so what's up with the tattoos?
This it says God.
Okay.
It's a God tattoo, and it says prolific. That's just me.
All right. I'm always interested.
Yes, ma'am.
Like, for example, did the face tattoo hurt?
Not really.
People always say that after the fact, but my understanding, when it's being done, it's painful.
It was small, so it didn't hurt.
Let's go get one.
All right. Once you start, you can't stop because otherwise you didn't spell the complete word. All right. Good luck to you in this court. In order to be successful on probation, communication is key. If there's an issue, you need to let your probation officer know about it. If you feel they're not addressing it, you can always come to the court. Whatever you do not just stop reporting
Yes, ma'am.
because no good can come of that, okay?
Right.
All right, good luck to you. Just remain in the courtroom and probation will go over conditions with you.
Thank you, Judge. May we be excused?
Yes. Can I have parties announced for the record for the state?
Michael Dwight Goins, the defendant, Your Honor.
And are you Daniel Cantu?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cantu, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Cantu, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is and was, Your Honor.
Mr. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $1,000 fine probated. There's no application for deferred adjudication. The state recommends community supervision. There's to be restitution of $60 to DPS. There's to be ignition interlock or alcohol monitoring device for half the term. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor, disregarding the terms of that alcohol monitoring device, I know the court recalls with their class, because they used to be ways until it will take his opportunity to get out the block.
Yes.
Okay, thank you.
All right. Did you understand that to be the plea?
Yes,
and
Your Honor.
defense?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. There'll be a top evaluation, 200 hours of community service restitution, DWI intervention, and victim impact panel. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Mhm.
Then to the offenses charge, how do you plea?
No contest.
State any evidence,
State author states one and a half.
No objection, Your Honor.
right? State, before you're excused, did anybody want to speak to the 10 days jail time?
State.
All right, thank you. State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client understands, especially after last week with the hearing on the pretrial matters, what he must do to complete this probation, and he's ready to get forward and move on with his life, Your Honor.
All right. So what was going on with you that day? I've read the police
That-
reports.
Oh, I'm sorry. I thought you meant last week, Judge. I
Yeah.
apologize.
That day?
Yeah.
So I got into an altercation with someone in the parking garage of the North Star Mall. And then just escalated with the security, which I already had an issue with to begin with since I
Well,
started
they're
working.
saying in the thing, they're saying it was over a parking space.
It It really wasn't. It was just a matter of she didn't want to move. We got into an altercation. I ended up parking. She saw me again. She says, "Do you want me to call the security? I work here. I know them." And then it just escalated from there. All I was trying to do was drop off some product to the place that I worked at, and it just escalated and escalated.
Do you still work for that place? All right. And are you currently employed?
No.
So how are you supporting yourself?
However, whatever means I can. Like I said, I've exhausted all avenues with my parents and stuff like that, so help me. So, did my 401k, everything that I can. I'm kind of not meeting ends meet at all right now. So,
So are you still looking for employment?
yes, constantly.
All right, this is what the court is going to do. The court is going to sentence you to 6 years in the prison, suspended and probated for 6 years. There's to be no contact with North Star Mall, regular reporting by Zoom or in person, proof of employment within 45 days, no employment as a home healthcare provider or with minors. There's to be restitution of $60 to DPS, 200 hours of community service restitution. And did you say you had children or no?
Yes.
All right. I'm gonna order parenting classes. Once that's completed, the community service hours will be deemed satisfied. There's to be a 2-year license suspension. In lieu of the 10 days in the Bear County Jail. Well, let me give you a choice. You can do 10 days in the Bear County Jail as a condition of probation, or I will give you 30 days GPS, ask that the GPS fees will be waived.
30 days GPS.
All right, in lieu of 10 days in the Bear County Jail, there's to be 30 days partial GPS to seek employment. DWI intervention. Victim impact panel live. TAP evaluation out of custody. Follow recommendations. There's going to be an affidavit of non-driving.
Your Honor, he's filed that in the pretrial matters. Is that good enough?
Yes, if you'll make sure that
Yes, Your
the
Honor.
probation has access to that.
We will, Your Honor.
There is to be weekly testing. Ms. Abrams, make sure they test for alcohol. And that's to be for 3 months. And thereafter, there's going to be either ignition interlock for half the term. If you have any access to vehicles. Or if no access, with an affidavit of non-driving, he can do a portable monitoring, alcohol monitoring device. There's going to be field visits 1 time per month for 8 months. And you're going to have to provide proof to probation monthly that you are seeking employment. And probation, are you all able to help him with employment search?
Yes, Judge.
All right, probation, is there anything else?
No, ma'am.
Oh, and I'm so sorry. There's $1,000 fine and that will be probated. Is there anything else you need from the court to be successful?
No.
Let me see if I can find your trial court certification.
I know I turned it in.
Yes, here it is. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, And because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. In this court, communication is key to be successful on probation. Do not disappear. Always make sure you report, okay? All right, good luck to you.
Thank you.
You're welcome.
May we excuse, Your Honor?
Yes.
Thank you, Your Honor.
In State of Texas v. David Barfield 3, the court handled a plea proceeding involving a charge of possession of a controlled substance, penalty group 1, in an amount of 4 to 200 grams, a second-degree felony punishable by 2 to 20 years in prison and up to a $10,000 fine. At the beginning of the hearing, the court disclosed that the judge had previously represented the defendant's uncle, Christopher, and confirmed on the record that Mr. Barfield had discussed the matter with counsel and waived any potential conflict. After that issue was resolved, the court confirmed that the state had complied with discovery and that defense counsel had reviewed the discovery with the defendant. Mr. Barfield acknowledged that he had reviewed the application for deferred adjudication, the indictment, and the court's admonishments with his attorney, understood the documents, and signed them. The court then carefully advised him of the charge, the punishment range, and the rights he would waive by entering a plea, including the right to a jury trial, the right to confront witnesses, and the right to remain silent. He confirmed that he understood those rights and intended to waive them. The court also explained that if deferred adjudication were later revoked, he could be sentenced to up to 20 years in prison and a $10,000 fine. Defense counsel stated that the defendant had been able to provide defenses, understood the proceedings, and was competent and legally sane at the time of the offense. Mr. Barfield further stated that no threats or promises beyond the plea bargain had been made, and that he was satisfied with counsel's representation. Under the plea agreement, the state recommended deferred adjudication and a $1,500 fine, with additional recommendations outside the agreement including 5 years of community supervision, a task evaluation, 120 hours of community service, restitution, a DEP, course MRT, and anger management. The defendant waived appeal, entered a plea of no contest after first appearing confused about the available plea options, and consented to the introduction of documentary evidence rather than live testimony. After reviewing the state's exhibits and attachments, the court found sufficient evidence to support guilt but deferred a formal finding because Mr. Barfield had applied for deferred adjudication. During sentencing, defense counsel simply requested that the court follow the plea agreement. The judge then questioned the defendant personally about his life and circumstances, learning that he was 32 years old, had a 13-year-old child with whom he maintained regular contact, worked as a quality inspector in the beverage field, and had been employed in that work for 5 years. When the court asked what a drug test would show that day and why he was engaging in this behavior, the defendant attempted to minimize responsibility by saying he was in the wrong place at the wrong time. The judge rejected that explanation, pointing to the stipulations showing that the pink backpack involved in the case belonged to him. The court then gave a stern lecture focused on the consequences of continued criminal conduct, especially for his children, warning that if he went to prison, his children might no longer recognize him and might end up calling someone else Dad. The judge urged him to improve his life, support his family, and bring honor to his family name. The court ultimately imposed 5 years of deferred adjudication with a probated $1,500 fine, regular reporting by Zoom or in person, random urinalysis testing, proof of employment within 40 days, no employment as a home health care provider or with minors, and no unsupervised contact with minors until completion of parenting classes. Because he lived with his grandmother, the court also warned him not to exploit that arrangement or bring trouble into her home and ordered monthly field visits to the residence until further notice. Additional conditions included MRT, anger management, restitution, and 120 hours of community service, with 60 hours deemed satisfied upon completion of parenting classes, and the remaining 60 hours to be satisfied either through actual service or by obtaining a GED or trade school certification. When defense counsel sought clarification, the court confirmed that the restriction on unsupervised contact with minors included the defendant's own child until he completed parenting classes. The judge explained that such classes were intended to make defendants reflect on their parental duties and the harm caused when criminal behavior interferes with their ability to support and guide their children. After confirming that the defendant had no further requests, the court reviewed the trial court certification of appeal rights, informed him that he had no permission to appeal because the plea bargain had been followed, and ended the hearing with practical advice that success on probation depends on communication with the probation officer and that failing to report would only worsen his situation. investigation.